Mr. V Pondo is here today after failing to appear before referee Coleman on April 26, 2024. Bond is currently set at $3,504. This is the second bench warrant. He reports that he is employed at Brembo. Last payment made on this account was in January of 2024. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 12th, 2024 at 8:45 a.m. before this court.
Mr. V Pondo, in this matter, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on June 12, 2024 at 8:45 a.m. Are you able to post a bond, sir?
Yes, Your Honor. While paying child support, I am. I'm working right now as we speak.
Okay. Well, you've been working, the last payment was in January of this year, correct?
Correct. I just recently got hired in Homer, Michigan.
Okay.
At Brembo. It's been a month now. And I live in Marshall by myself, and I've just been catching up on everything one day at a time.
Yeah. Well, obviously you haven't caught up on your support, so.
Yeah, I'm working on it. That was something that I'm getting to. I got a motion in play right now as we speak, and I go to court for that for July 24th.
Yeah. Okay. Well, that's not in regard to what anything we're addressing at today's date.
Well, I'm trying to say, Honor,
I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond, reduce your bond to $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, I don't, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
24 at 8:37 a.m.
Good morning to both of you. This is before the court for a status conference to determine the progress of the case. Ms. Mundey, as you are the plaintiff, you have a little bit more control of everything with regard to the pleadings. Tell me what's happening in the case.
I filed the uniform child support order and the judgment information and the judgment of divorce.
Okay. When did you submit those?
Monday.
Okay. Well, it usually takes a week to a week and a half or so to get those back. So if you do get any objection from the front of the court, make sure you take care of that right away, because your case is getting dangerously close to being old. And if it gets too old, the court will dismiss the case. And I don't think you want to go through that.
Right. Okay.
Okay. So if you get an objection, what we'll do is we'll set this on for about a month. That way we don't lose track of it.
Okay.
And obviously, if we get the front of the court approval and all of that, in the meantime, did we take proofs on this?
We have not preserved proofs yet.
This Monday, I'm going to take some testimony from you. That way, if in fact you get the front of the court approval, then you wouldn't have to come back in. Okay.
Okay.
Okay. So if you would raise your right hand, we'll have you sworn in. Ms. Mundey, in this matter, you filed a complaint seeking a divorce from the defendant in this case. At the time that you filed that complaint, had you resided in the state of Michigan for more than 180 days in the county for more than 10 days immediately preceding the filing?
Yes.
And in the complaint, you state that there had been a breakdown of the marital relationship to the extent the object of matrimony had been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. Is that a correct statement?
Yes, Your Honor.
Was everything else contained in the complaint true and accurate when you filed it, and does it remain true and accurate?
Yes.
Are you currently pregnant?
No.
Court will find that the testimony does establish the statutory basis. The court will preserve the proofs in this matter pending receipt of approval of the front of the court. Upon receipt of that approval, the court would then enter the judgment and UCSO in this case. So hopefully we can get that matter taken care of relatively quickly. So you're free to go, and we will see you back in 30 days if we haven't received the approval before then.
Okay. Thank you.
Okay. Thank you. Mr. Clore, are you having any objection to the judgment? Have you seen that yet?
No, I have not seen it yet.
Okay. If you do have that, you can always file an objection. That way it'll put the court on notice that, that there's some dispute.
Okay,
Okay?
Yep.
Thank you.
thank you.
Free to go.
Just
Okay.
one thing, did you mean Monday, June 3rd that you submitted to FOC?
Yes.
Okay, thank you. Just for our records here, 41
Okay,
AM.
thank you.
Good morning to both of you.
morning.
Ms. Weyer, I do note we received information the front of the court had filed an objection back on April 12, 2024. Have you
Yes.
submitted your
Yes.
judgment? And when did you,
I
when did
resubmitted.
you, when did you do that? When did you do that?
I just resubmitted the final copies last night after speaking with someone back and forth. I finally got it figured out. So I emailed it last night.
Okay. So Weyer, have you received the judgment and all the other paperwork, the UCSO, et cetera?
Yes, I have.
Are you objecting or disputing anything?
I am not.
Okay. Well, what we'll do is wait and see when we get that objection, when we get the approval. Ms. Weyer, you're gonna then have to contact the court and set up a pro confesso hearing at that time. And so hopefully what I'll do is I'll put this back on we'll reset it for 30 days in case we haven't heard anything. I assume we will, but in the event that we get another objection, we'll want to be able to keep track of the case. So if in fact they do approve it, then ma'am, you can reset the pro-con anytime within that on any Wednesday. And therefore, then we could dispense with the follow-up status conference.
Okay.
Okay. Okay. Thank you both for appearing, and you're free to go. Have a good day.
All right. Thank you.
Thank you.
The defendant is present via telephone.
Good morning to both of you.
Good morning.
Miss Cryder, I'll go with you first because you are the plaintiff. Tell me what's happening in the case.
We're currently making adjustments to the child support, and that's where we're at right now, which is what we were going to discuss with you today.
Okay. And what did you want to discuss about that?
It was sorry, I'm trying to think because
It's mostly on my side.
Okay. Well, enlighten me. What's happening?
So I believe the way that the numbers have been calculated, I believe are based off of Michigan numbers, and they're just really, really high for where I live. So I've been trying to work around it, and I've been discussing it with Bailey, and instead of using the calculator, as long as the courts and yourself are okay with it, we haven't agreed upon a number that we'd like to move forward with the child support, if that's acceptable.
Well, let me tell you, that number and the calculation depends upon where the children are residing. The children are residing in Michigan, I assume. Is that correct, Ms. Cryder?
Yes.
That has nothing to do with where you live, sir. So the fact that you live some other place is not relevant to the particular issue. Ma'am, are you receiving any public assistance on behalf of the children?
I get Medicaid.
Okay. If you're on any public assistance, you cannot deviate from the child support calculation, because the money that's paid in child support would go to reimburse the state of Michigan for the expenses that they're paying on behalf of the children. So in this case, you're not going to be able to deviate.
Okay. Is there a resource available that I can get a more accurate representation? Because as of right now, the numbers on this calculator are going to put me on the streets, Your Honor. I won't be able to live or function normally. It's asking for almost 30% of my income.
There is no resource that you're not entitled to an attorney in these cases, in domestic cases. So what you'll have to do is you'll have to contact your own attorney or find some means, find an attorney that might take it pro bono or something of that nature, but there are no other services available.
Okay.
So
In that case,
go ahead.
In that case, I'd like to ask for an extension on my timeline for getting this paperwork back to the courts.
Well, what paperwork?
the child support response?
Well, obviously, I don't know when she submitted that to you. Ma'am, when did you send that out to him?
It's about a month and a half.
Okay, a month and a half is by far enough to make an objection, sir. I'm not going to extend anything in this matter. You're going to need to do it. If you have an objection, or if you want to file some motion or something, you can do that in a day. It doesn't take a long time to do that. So it's just something you're going to have to do, and you're going to have to do it expeditiously, because I don't want that holding the court up. So go ahead and file what you need to file, whether it's a motion, whether it's an objection, etc. And then the court will address it at the time that you set a hearing on the particular motion.
Okay.
But I will tell you, just so you know, that the court is required to follow the child support calculation based upon the Michigan child support formula. And that is by statute. The court can't vary from that, other than there's very limited basis that the court can do that. And so far what you've said doesn't satisfy that particular basis, but you're able to file a motion if you wish to do so. Okay?
Yes, sir. I understand.
Okay. Thank you, ma'am. What I do is suggest to you get all the paperwork together, the final judgment, the UCSO, and the judgment information form. Get those submitted to the front of the court so they can prepare to, again, either approve or object to those. Okay?
Okay.
When should we reset a status for this one?
About 60 days. We're going to reset this in about 60 days. That'll give you more than enough time to get all that paperwork done, get it to the front of the court, and hopefully we'll have front of the court approval, and we'll be able to complete the case at that time.
Okay.
Okay.
I'll try to have a response to the custody within the week.
Okay. Thank you.
All right,
No
thank you.
problem.
We will close the record here for today.
You're free to go. Have a
We're
good
back on
day.
the record.
Thank
Mr. Bush, in this matter, you're charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes, I do.
Court has appointed Ms. Perkins to represent you in this matter. Have you had sufficient opportunity to speak to Ms. Perkins in preparation for this hearing?
Yes, I did.
Okay, Ms. Perkins, are you ready to proceed?
Yes, I am.
Okay. Mr. Bush, I'm going to take some testimony from you and Ms. Platt. We'll have you raise your right hand, be sworn in, then we'll
The matter of
proceed.
Vasquez versus Bush. In this matter, Lamont Bush is appearing for an adjourned bench warrant hearing that was adjourned by your honor to allow him to appear with counsel. He is presently ordered to pay $516.50 each month. It's $376 for the current monthly support, $87 for monthly confinement, $50 towards arrears, and then the $3.50 service and processing fee. His last payment in this case was made through income withholding on November 15th of 2023. That was for $132.53. This is the first bench warrant. He's had one prior show cause with no findings of contempt. He failed to appear on September 5th of 2023 for a show cause hearing before the referee. Compliance was measured over 12 months at the $516.50 per month obligation. During that time, he paid $265.06. It left him short $5,932.94 for the year. In this matter, he did post the $200 bond. Front of the court's requesting that be forfeited and applied. However, he remains in jail on 3 charges unrelated to the front of the court. We have his book-in date showing originally May 9th of 2024. He's been sitting since that date.
What is the total arrearage in this
Oh,
matter?
I'm sorry, I missed that, Judge. Total arrearage is $8,948.45 as of the end of May.
Thank you. Ms. Perkins, do you dispute or contest the statements made by Ms. Platek?
No,
Do you have any questions for Ms. Platek?
I have no questions.
Okay, any proofs, Ms. Perkins?
Your Honor, back when my client had his income withholding taken out, he was working on installing solar panels, and that was a job that finished, and everybody was let go afterwards. And therefore, after that, he was having a hard time finding a job. He did line up a new job, Systex. Unfortunately, he did get picked up in the jail, so he was not able to start that job. However, that job is still holding his position open for him. The other matters he's in jail for, he's going to court on Friday, and he believes that he will be let out of the jail from that at that time and be able to start Systex soon after that. What we're asking for is an adjournment of these matters to give him the opportunity to get out of jail and get that job started, to get that income withholding put back in place. He does want to be paying his child support. He does not want these to continue to add. He was just having a hard time there for a little bit, but it sounds like everything's getting back on track, and we're asking for that opportunity to let him get back on track.
Okay, thank you. Mr. Bush, in this matter, obviously you have a sizable arrearage in this particular case, and haven't paid since November of 2023. Tell me what's happened since November of 2023.
Like she said, it's really been hard. It's really been hard for a lot of people to get jobs out here because it's been a freeze in there, like in employment. But I've been looking around for jobs and everything. Like she said, and I had found a job at Systex. I was supposed to start Tuesday, but I ended up getting in trouble for getting pulled over. Well, not even pulled over. I had the police pulled up on me and just was talking to me and found out I had warrants, and it took me into custody.
Okay, tell me from November to the date that you were picked up, what did you do to acquire employment?
I kind of was just doing little under the table jobs for family members and stuff, because I had ended up moving to Minnesota for about 2 months, 2-3 months.
You were what? I didn't catch you. Were what for 2 or 3 months?
I was doing under the table work for my cousin in Minnesota. She owns her own business, but she just let me do little under the table work because I needed my license. And I didn't have them at the moment. They were suspended, and now I have my license. So I possibly might be moving back to Minnesota to work for her if I get out and the Systex doesn't work out for me, which it should.
If you were working for those 2 or 3 months under the table for this person, why were you not paying support?
Honestly, Judge, I wasn't thinking about it at the moment. I was more or less I was helping my baby mama out instead of paying the courts on that. I wasn't thinking of it.
Okay. What's your education background, sir?
I was supposed to graduate 2015, but I had left school in 11th grade, so I've recently been in the process of trying to get my GED. I've taken 3 of the tests at YMCA. I got 1 test left to take.
Okay, so you haven't got the GED yet?
No, but I am in the process.
Okay. Anything else you'd like to tell me, sir?
No, sir.
Okay. Anything else, Miss Perkins?
No.
Well, in this matter, the court does note that Mr. Bush had worked and paid his support obligations sporadically up through November 15, 2023, at which time he discontinued paying support obligation. He's now approximately $9,000 in arrears, but his obligation is only $516.50 per month. So he has considerable time before that he was not paying. In this case, he stated that he was working under the table for 2 to 3 months since November, but as he said, he was not thinking about the support obligation, therefore he was not paying it. The court will find that he did have available resources and could have paid support. He did not do so, and therefore did not make a good faith attempt at compliance, failed or refused to comply, and he is in contempt of court. Anything before sentencing, Ms. Perkins?
No, Your Honor.
Okay. Well, first, the court will forfeit the bond previously posted by Mr. Bush in this matter. The court could sentence you, Mr. Bush, up to 45 days. It looks like you spent 27 days incarcerated in this matter. The court will sentence you to 27 days with credit for 27 days served. As a result, you would not have to spend any additional time in jail on this particular matter. And I'm doing that because, again, it is your first bench warrant, first time you've not had any prior findings of contempt. So that is why I'm doing it, but I will let you know that in subsequent hearings, if you have not been paying, that it can go up to 90 days in this matter. You understand, sir?
Yes, I do.
Okay. But you're free to go. Have a good day.
Thank you. I appreciate it.
Okay,
Can you hear me?
all right.
Yep, we can hear you. Find a place where you get rid of reception. Sit down, sir.
Yes, sir. I'm just getting out of the house for the kids.
Okay, movement is distracting to the court. Okay, Mr. Forthofer, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes, sir.
Court had appointed Ms. Perkins to represent you in this matter. Did you have sufficient time to speak to Ms. Perkins in preparation for this hearing?
Yes, thank you.
And Ms. Perkins, are you ready to proceed?
I am.
Okay. Mr. Forthofer, I'm going to have you raise your right hand, be sworn in.
160S in the matter of Regal versus Forthofer. In this matter, we are here on an adjourned show cause that was adjourned in April to allow the respondent to complete his CDL class and begin paying as ordered. The current obligation in this matter is $1,683.50 per month. That's $1,483 for current, $197 is the guideline amount for him to be repaying the arrears, and the $3.50 service and processing fee. The only payment made since the time of the adjournment was yesterday, June 4th, for $300. He paid that on his own. This is the second show cause with no bench warrants and no contempt findings, but I do want to remind the court that this is now the 9th hearing we've held due to adjournments. Compliance was measured over 2 months at the $1,683.50 per month obligation. During that time, he paid the one $300 payment, which left him short $3,067. Current arrearage as of the end of last month is $9,846.54, and he has had no previous jail sentences in this matter.
Okay. Ms. Perkins, do you contest or dispute any statements made by Ms. Platic?
No,
Do you have any questions for Ms. Platic?
no questions.
Okay, any proofs, Ms. Perkins?
Your Honor, my client has been working diligently to try to get his CDL. He has taken several tests, and it's several different parts that he has to take. He has to take written tests. He has to take another test where he's backing up the truck and doing several things like that. And then there's a road test. And this Friday, he is doing another part of that CDL test. There was a couple of times he failed certain things and had to redo them. So he has been working diligently to try to get his CDL. He is confident that this Friday, after that test, he will be able to pass everything and finally get that CDL and be able to start working. He has been in contact with several different places that are hiring for truck driving, and they have all told him, once you get that CDL, get back to us and we'll talk about employment. So they're not going to talk to him before he gets that CDL. And like I said, he's got that last test that he has to do this Friday. So what we're asking for is another adjournment to give him that opportunity to finish that up. He has been working diligently on it. It's not like he's been taking his time or wasting his time. He's been working on it. He just needs that a little additional time to get that done and be able to start working. He does want to be paying this child support. He does not want it to continue to get worse. He wants it to get better and get behind him with regard to this. And we're just asking for you to give him that opportunity to finally get this done for him. It's been a hard road for him. He was working at Feral Gas there for a little while. They were working with him with regard to getting a CDL, but then the person that hired him got fired, and then he got fired after that. And that was not due to his fault, but the company wasn't believing, since the person that hired him got fired, wasn't believing certain things. And so he's had issues with regard to this, and we're just asking for a little additional time.
Okay, thank you. Mr. Forthofer, in this matter, she states that you'd worked with Feral Gas. How long had you worked for them?
About 3 months.
Okay, and when was that 3 months, the time frame?
That was, let's see, September to, I'm getting confused here. End of November, or It was in December, I believe. Not a very good time to get fired. I don't know the exact dates, but
Was that in 2023?
Yes.
And obviously, based upon the amount that you paid, that you didn't pay support during that time. Why not?
I called the courts like I should, and honestly, just thought that it was going through. Everything's done electronically, and I thought I was all caught up and or on a good path of being caught up. And then I find out that they never answered back to friend of the court and get that all lined up. But I learned that it's all on me. My negligence.
It's easy enough. See, it's easy enough to look at your paycheck stub or a computer printout or whatever you have. You'd know whether the support obligation was being paid. It's $1,600 and something. You'd know if that's being taken out each month.
At the time, it wasn't that much. It was $500.
Regardless, how much? Let's say it's $500. If your check isn't coming out with $500 less, you obviously know that it's not being paid.
Yeah, I understand. Everything's done electronically, and I'm not that guy. It's everything's done electronically on the phone. Resumes, you can't do any pay stubs.
Okay, sir, none of that matters. If I know that I'm making, let's say gross per month, I'm making $2,000.
Yeah.
So I know that my net is, let's say, $1,400. If I get a check for $1,400, I know that they're not taking out child support. Why is that difficult?
That whole situation with that job was just difficult and confusing. I got hired. We want you to deliver these tanks, and then we're going to get you in this truck and deliver bulk. And then Scott gets fired. And
sir, I don't care what jobs you were doing. I care that you were working and being paid and not paying your child support. So all of this is just deflecting from the fact that you didn't pay.
There was the full custody thing going on with my kids, and just a lot going on in this child support. It is my fault. But I just, it's a lot going on in my life and a lot of stress, and that job didn't help. But yes, it's my fault. But I'm just telling you honestly how it is, and I won't make that mistake again. I can tell you that.
Okay. Ms. Briegel, is there anything you would like to tell me?
I wish that the front of the court would have been able to prove that the CDL testing has actually attempted to even take place, because I don't believe he's shown up for those things despite him saying that he hasn't passed. The reason for that is because I spent almost 8 years with Michael, and he had a CDL at that time. So this isn't something new for Mike.
Okay. Anything else, ma'am?
Nope. I'm just ready for court to be over.
Okay. Ms. Perkins, anything else you have, or any questions for Ms. Briegel?
No, Your Honor.
Okay. Anything else, Ms. Perkins?
No, thank you.
Okay. Well, in this matter, the court will make the following finding. In this case, Mr. Forthofer is obviously had a period of time back in September through either the end of November or sometime in December. He was working for Feral Gas. He was obviously being paid at that time. He was fired as a result of, again, his supervisor being fired, but notwithstanding that, he had income for those 3 months that was not paying any support at that particular time. The court will find that he did not pay out available resources. He failed or refused to pay, and therefore he is in contempt of court. Anything before sentencing, Ms. Perkins?
No, Your Honor.
Well, the court note that he does not have a prior finding of contempt, and the court is taking that into consideration. He had 2 prior bench warrants, but again, the court does believe, based upon, again, the total disregard of the support obligation in this matter, that I could sentence you, Mr. Forthofer, up to 45 days in jail. I'm not going to. what I'm going to do is I'm going to sentence you to 14 days in jail with credit for no time served. Court would order that you report to the Calhoun County Sheriff Department no later than 4:00 p.m. on June 21st, 2024. I'm giving you that couple weeks so that you can get the testing that Ms. Perkins states you're taking this week or next week, whenever you have to, but you'll have that period of time to get it done. What I will do is state that in this matter that, again, the court will allow you to purge yourself of contempt by paying the sum of $1,000 prior to the June 21st, 2024 date. So if in fact you pay the $1,000 before that date, you do not need to serve the 14 days. If not, you need to report to the jail at that particular time to serve your time. If you do not report, sir, I will let you know that there could be additional charges. You could be held in contempt of court and spend 90 days in jail at that time. So you need to report if you don't pay the purge amount. You're free to go and have a good day.
Thank you.
That's all you have, Ms. Burke or Mr. Moore. In this matter, he is your respondent. Is that correct, Ms. Gilman?
Yes.
Mr. Moore, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes.
Okay. And the court has appointed Ms. Perkins to represent you in this matter. Have you had sufficient opportunity to speak to Ms. Perkins in preparation for this proceeding?
Yes.
Ms. Perkins, are you ready to proceed?
I am.
Okay. Ms. Gilman and Mr. Moore, I'm going to have you raise your right hand and be sworn in.
Arthur Moore's total monthly obligation is $168.50. That is $15 for current support, $50 for arrears, and $3.50 per month for service and processing fees. Their last voluntary payment was $115 on January 4th, 2021. This is their second show cause. They have had 4 bench warrants and 0 contempt findings. Friend of the court has monitored their compliance for the last 6 months at the rate of $168.50 per month. They should have paid $1,011. They have paid nothing. The total shortfall is $1,011. Their total arrears are $5,837.73 through June of 2024. They have not reported any employment, nor has any been located. They have posted a bond of $500. Friend of the court is requesting to forfeit the bond.
Okay. Ms. Perkins, do you dispute or contest the statements made by Ms. Gilman?
No, Your Honor.
Okay. Do you have any questions for Ms. Gilman?
No questions.
Any proofs?
Your Honor, my client fell into a deep depression when he lost his brother and his stepfather. Both of them passed away, and he wasn't doing much of anything after that. Since then, he's been able to work through that. He's now getting back into things and trying to get a job. He does have an interview today with a power wash company to power wash trucks, and he is hopeful that he will be able to get that employment. He does want to pay. He does not want these arrearages to continue to accrue. And what we're asking for in this adjournment to allow him to go to that interview today and get that job lined up to get income withholding put in place so that he can start paying on these on this child support matter and start working towards getting rid of the arrears.
Okay, thank you. Ms. Moore, in this matter, when did your brother and stepfather die?
My stepfather just passed away like a month ago. My aunt just passed away yesterday morning, and my brother died like a year ago.
You understand, Mr. Moore, that obviously a lot of people have relatives that pass away. They still continue to work. They still continue to, again, meet their obligations, et cetera. And unfortunately, you have the condolences, but again, that's not a free pass that, okay, I never have to work again. You understand that?
Yes, I'm on my way to an interview right now, sir.
Okay. Let's say, okay, I'm going to put her on mute so we don't have to hear that.
She said that she was at work.
Okay. Sir, in the last year, what have you done to acquire employment?
I haven't done much, sir. I just started trying to get a job. Like I was in depression. I apologize to everyone. I didn't know what to do.
Okay. What's your education background, sir?
I have a high school diploma.
Okay. When was the last time you worked full-time employment?
It was like 2019, 2020.
Okay. Anything else, sir, that you'd like to tell me?
I'm really trying. Like I said, I was suffering from like mental health. I'm getting better now. I'm really trying. I'm not a crumb dad. I just didn't know what to do. I didn't know what to do. I truly didn't know what to do. So I just shut down. And man, I'm really trying. I'm really trying. I gotta, man. I don't even know what to say. Like I don't know. I don't know. I'm sorry.
Okay.
I'm
Miss
trying.
Robinson,
I'm really trying.
if you don't mute her. Miss Robinson, is there anything you'd like to tell the court?
My daughter is 8 years old and she has never met that man. He does not try to pay child support. The only time I get any help or money is when you guys finally catch up with him 3-4 years later. This is crazy. I have 6 kids too, but I work full-time job. I have hustles on the side. Like there's no excuse. There's really not.
Okay. Anything else, ma'am?
No, I mean, no. We all go through problems. Like you said, we all still have to make a living and support our children, regardless of what we're going through or what comes up.
Okay.
Like I said, that little girl is 8 years old and has never met that man. He does not try to be in her life. He does not try to help me. He does not try to do anything.
Anything else, Ms. Perkins?
Nothing further. Thank you.
Well, court will make the following finding in this matter. Mr. Moore had a brother who died approximately a year ago, and then some aunt and uncle most recently. But notwithstanding that, as he says, that during that time he didn't do much. As he said, not much. He not know what to do. Well, I can help him out. What to do is you get a job and you move on as most people do, because you have to sustain yourself and to meet your obligations. And just because you were depressed and didn't find you were able to work, that doesn't mean that your child should suffer as a result of your failure to pay child support. So court will find in this matter that Mr. Moore, in fact, failed to make a good faith attempt at compliance, failed or refused to comply, that he had the ability to do so, that they had no, again, they had no restrictions or nothing that would keep him from working. As he states, he has an interview today. And as a result, the court will find that he didn't make a good faith attempt at compliance. He therefore is in contempt of court. Anything before sentencing, Ms. Perkins?
Nothing, Your Honor.
Mr. Moore, the court could sentence you up to 45 days in jail. I'm not going to do that because it is your first time where the court would potentially put you in jail. First, the court will forfeit the bond previously posted in this matter. I'm going to sentence you in jail to 21 days in jail with credit for no time served. The court will order that you would report to the jail no later than 4:00 p.m. on Friday, June 14, 2024. The court would allow you to purge yourself of contempt by paying the sum of $500. So if you pay the sum of $500 before the June 14, 2024 date, you do not have to spend time in jail. Otherwise, you would have to spend the 21 days. I'll advise you in this matter, if you don't appear, if you don't pay the $500 and you don't appear in jail by the June 14th date, the court can sentence you or find you in contempt of court and sentence you up to 90 days in jail. So if you don't, again, comply and serve the 21 days, you could get up to 90 days in jail. So that will be the sentence and the order of the court in this matter. I'm giving you that time, approximate week and a half, sir, to raise the $500 if you need to stay out of jail. So you're free to go today.
Sir.
Best of luck. I hope things work out. And court will conclude this hearing.
Thank you.
Hello, Mr. Alman, can you hear us?
Mr. Alman, are you present?
Do you have his phone number, Erica?
One moment.
Yeah, because I think the connection, his connection is failing. Can you hear us now, Mr. Alman?
Yes, sir.
Okay, one moment. Just
Mr. Alman, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
What's that, sir?
Do you understand what you're charged with, sir?
No, sir. I don't. I'll be honest with you, I don't.
Okay, you're being charged with civil contempt of court for failing to pay child support and related expenses. You understand that?
Yes, sir.
Okay. And court has appointed Ms. Perkins to represent you. Have you had sufficient opportunity to speak to Ms. Perkins in preparation for this hearing?
Yes, sir.
And Ms. Perkins, are you ready to proceed?
I am.
Okay. Mr. Alman, I'll have you raise your right hand, and Ms. Barrington as well. We'll have you sworn in, then we'll
Agency
take
placed
some
foster care versus Ronald Lee Alman Jr. Mr. Alman's total monthly obligation is $681.50. He is ordered to pay $480 per month for current support, $198 per month on arrears towards according to guideline, and $3.50 per month for service and processing fees. His last payment was $53.16 on February 12th, 2024 through income withholding. This is his first show cause. He has had one bench warrant and no contempt findings. I've measured his compliance during the past 12 months, including the $300 bond he posted in November. He should have paid $8,478. He has paid $358.16 for a total shortfall of $8,119.84. The total arrears on this case as of May 31st, 2024 are $9,896.53. Mr. Alman does qualify for food stamps and Medicaid. Mr. Alman has been provided with multiple opportunities to submit current and adequate medical documentation, file a motion to address his obligation, or otherwise gain compliance through regular employment, and he has failed to do so.
Okay, thank you. Ms. Perkins, do you dispute or contest any statements made by Ms. Barrington?
No,
Do you have any questions for Ms. Barrington?
no questions.
Okay, any proofs, Ms. Perkins?
Your Honor, my client is unable to hold a job for very long. When he does get a job, he cannot hold it due to his disability. He has problems with diabetes, neuropathy in his feet. He's got back issues that prevents him from doing certain jobs. He has filed for disability, and he is anticipating his award letter sometime within this month for a Social Security disability. With regard to the paperwork that the friend of the court has been requesting, he did drop that off to his doctor at Grace Health. He did not realize that they wouldn't just do the paperwork and give it back to him. When he learned that he had to stay on top of them to make sure they would do it, he did follow up with them, and they said, oh, we're not going to do that until you come in for an appointment. And he does have that appointment scheduled for the end of next month. So he is doing what he needs to do to prove the medical issues that he has. He tried to do the paperwork, but he did not understand the process that Grace Health is different than other doctors that would fill out paperwork of that nature. So we're asking for an adjournment of this matter to give him the opportunity to go to that doctor's appointment, fill out that paperwork, and also get his award letter that he's anticipating for this month, so that they can get the information that he has regarding his disability with regard to this.
Okay, thank you. Ms. Barrington, you stated, have we adjourned this before for Mr. Alman to get the medical documentation in?
More than once, Your Honor.
When was the first time that he was requested to get that medical documentation in?
At the show cause hearing on June 12th, 2023, before the referee, that hearing was adjourned 60 days to allow him to provide medical documentation. He failed to provide that medical documentation and then failed to appear for the adjourned hearing.
Okay.
What?
Okay.
I've never failed to appear.
Well, do you remember, sir, the hearing that you had with the referee on June 12th, 2023?
No, sir. I know I had one, but I don't remember exactly what the contents were and why it was adjourned. But I don't.
It was adjourned. It was adjourned, sir, so you could provide medical documentation, and you didn't do that. Let me ask you,
No, I did not.
Mr. Alman, have
Yes,
you,
sir.
you've
Yes, sir.
applied for, okay, you've applied for disability, is that correct?
Yes, sir.
Had you previously been denied disability?
I was denied because of work credits. I filed wrong. Hey, am I still here?
Yes, you're still here.
Okay, I'm sorry. It got quiet. I'm sorry. But yes, I have applied. Yes, I was denied. It was for my work credits. And I was denied before because they got the wrong medical information. They actually got my father's medical information instead of mine.
Sir, how have you been supporting yourself when you've had no income?
I was staying with a friend for a while. They were assisting in helping me out. I was trying to get jobs in between there. I've had various jobs, trying to hold jobs in between, from Meyer to Helcon to WSI, and it's just I can't hold that. I can't hold those jobs.
Why is that?
Standing up and working, I want to, but when I stand up and I work for too long, it causes my back to bulge. There's a bulging disc in my back, and it causes that to pinch that nerve in the back as well. I have trouble standing because I have no feelings in my feet. So I mean, there's issues when it comes to actually trying to hold these jobs, and when I can't come into work or I'm bed rest, if you will, because my back bulges out and I have to let that go back into place. They can't hold me. They can't keep me at work because I'm not a consistent worker.
Well, have you looked into any occupational therapy or anything of that nature to get you into a job where, let's say, you have a job where you're sitting as a receptionist or something of that nature?
Yes, I have. Yes, I have actually, sir. I've actually called up to Michigan Works and talked to Michigan Works. I've talked to Mickey at Michigan Works to look at helping me see if she can help me find something that would work with my diabetes. They've also are looking at putting me into the CDL-A course and going through that to maybe be a driver.
Okay.
And I'm supposed to bring my documentation up to her sometime this week. I just had to get my resume. They're going to help me print out my resume, and I'm just waiting for her phone call back to verify because right now I don't have my Social Security card. So when I went to Social Security, I actually applied for my Social Security card to come in. But until then, it's like I don't want to wait. So I have a copy of my Social Security card. If they will allow me to bring in just a copy and then maybe bring in my Social Security card after, I don't know the facts on that. So I've called her already to get confirmation. I'm waiting for her to get back in the office. She was out last time I called her, which was on Friday. I called her on Monday. She was out. So I left her a message on her phone. I just need to know if I can bring in photocopies of this stuff and they'll accept them. If that's the case, I can get that turned in and I can get started on the class for my CDLA.
Do you have any idea how long is the CDLA class?
What's that, sir?
How long is the course for your CDL?
I'm not sure on the length of the course. I think it's like a 2-month course or something like that.
Usually,
but I'm not exactly sure on the length.
Usually it's less time. I haven't heard of any of those that are 2 months. I've heard of them as, I think the longest was 6 weeks or something, but
6 weeks? Okay. That sounds about right. And then she said also, upon completing that course and passing the class, they help you get into a job.
Okay. Sir, what I'm going to do is, obviously you've had a lot of adjournments previously, and unfortunately I'm going to give you your final adjournment in this matter. I'm going to adjourn this matter to August 21st. And that way you'll be able to get, as you say, you'll be able to get maybe some response on your Social Security as well as your doctor's information and those documentation as to your ability to work. I will tell you, this is the last time that you're going to get an adjournment in this case. You understand that?
Yes, sir.
So we'll see you on July 21st and I'm sorry, August 21st, 2024 at the same time. And you better have all of the documentation, everything else. I don't want to hear at that time, well, I wasn't able to meet with my doctor, or, oh, I don't know this, or I don't know that, because we're going to proceed.
There will not be. I didn't mean to interrupt you, sir. I apologize, but there will not be any excuses. I'm diligent with this, and I'm determined.
Well, I'm giving you this opportunity to, again, get all this stuff done so that we have all the information necessary in this case. But again, this is the last opportunity.
Yes, sir.
Okay?
Yes, sir.
Okay. We will then see you back on August 21st, 2024. Thank you.
Thank you, Your Honor.
Right. Thank you for your patience. We're ready for you.
Okay. Mr. Davis, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. In this matter, understand in this case, the court could, if the court finds you in contempt of court, you could be sentenced up to 45 days in jail. If it's a first offense, or if it's a second or subsequent offense, up to 90 days in jail. You understand that?
Yes.
And in this matter, the court has appointed Ms. Perkins to represent you. Have you had sufficient opportunity to speak to Ms. Perkins in preparation for this matter?
Yes.
And Ms. Perkins, are you ready to proceed?
I am, Your Honor.
Okay, thank you. Mr. Davis, what I'm going to do in this matter, I have you and Ms. Kolf raise your right hand, be sworn in, then we'll take some testimony.
We're here today on both cases for an adjourned bench warrant hearing after the respondent failed to appear before Your Honor on February 21st, 2024. On docket number 2013-1719, the respondent's total monthly obligation is $95.50. This comes from $67 for current support, $25 ordered on arrears, and $3.50 for service and processing fees. Last payment made on this docket was $23.09 on February 12th, 2024. This is the 7th show cause. There have been 9 bench warrants and 1 previous contempt finding. I have monitored the compliance for the last 6 months at the rate of $95.50 per month, meaning he should have paid $573 and he has only paid $123.09, making the shortfall for the last 6 months $449.91. Total arrears on this docket are at $4,125.91 through the end of May. On docket number 2021-1425 DS, his total monthly obligation is $338. That comes from $223 for current support, the guideline amount of $111.50 per month on arrears, and $3.50 for service and processing fees. Last payment on this docket was $76.91 in February of 2024. This is the 3rd show cause. There have been 3 bench warrants and 1 previous contempt finding. Monitoring compliance for the last 6 months at the rate of $338 means he should have paid $2,028 and he has only paid $176.91. Total arrears on this docket are at $11,621.40 through May 2024. Friend of the court would like Your Honor to be aware that the respondent was previously given a 21-day jail sentence for contempt in June of 2023. He has failed to participate in LEAP twice previously, and he did post a $970 bond on the 2013 docket and a $2,701 bond on the 2021 docket.
Okay. Ms. Perkins, do you contest or dispute any statements made by Ms. Tolf?
No, Your Honor.
Do you have any questions for Ms. Tolf?
No questions, Your Honor.
Okay, any proofs?
Your Honor, with regard to the case with the 2021 docket, my client indicates that he has his son in his care with regard to that. So, and his daughter is living with an aunt. I went over with him that he needs to file friend of the court paperwork with regard to that to modify the child support, because he shouldn't be paying monthly support on a child that is in his care. He indicated that he will be doing that. And also in the 2013 docket case, he has that child in his care as well. The mother has moved out of state and he has that child in care. We also went through him needing to file for a child support modification with regard to that case as well, so that he's not being charged current support on a child that is in his care. He is taking care of his children. He is not just not taking care of his children since they are in his care. So we are asking that you allow an adjournment so that he can file the necessary paperwork with the friend of the court for both of these cases to update that children are with him, and to get rid of these current monthly supports with regard to that, so that they can be modified, and the one with the daughter that is not in his care be at a more reasonable rate that he can pay regularly with. He is not a father that is not doing his obligations. He is taking care of his children. We want you to take all that into consideration and allow an adjournment.
Okay. Ms. Tolf, are you aware of the fact that he has custody of the children?
No, I was never told that prior to right now, Your Honor.
Mr. Davis, why did you keep this a secret and didn't say something to Ms. Tolf about having custody of these kids?
Your Honor, this isn't my first rodeo. I've had my kids before, and I've came and filed out the paperwork. Did the paperwork, never got a response. I've called, never got a call back. This was a few years ago. So I figured, like, I'm at a loss either way it goes.
Let me tell you, Ms. Tolf hasn't been in front of the court for a couple of years. She just got in last year, so she wouldn't know any of that information. So if you want somebody at the front of the court to know something, you got to tell them that. You can't assume that they know something that happened years ago.
Sir, I've done this. I've said, like, I've been through this before. The last time I've notified and let it be known that I have my children, nothing happened. I was still paying child support. So here we are again. I'm at a loss either way it goes.
What you're going to have to do is file a motion with the circuit court clerk's office. When you file a motion, there's a notice of hearing. You will schedule it for a hearing at that time as well. And then the matter will be heard. And you say, well, I didn't hear back. Well, if you don't schedule for a hearing, you won't hear back because you won't get a hearing date, but that's up to you. You have a right to schedule it. You can schedule a hearing before me any Monday that there is at 10:30. So, and if you schedule it, it's going to be heard on a Monday at 10:30. So you're not going to be gone for months or years at a time without hearing back, because we have to hear those when they're scheduled.
Okay, that's the first time I've heard that part. Like I said, I went through this maybe 3 years ago, and
go to the clerk's office, ask for an improper motion. You will file the motion first you can file a motion to change custody and to modify your support, because that's what apparently you want to do. Okay. And you get that scheduled. You can schedule that any Monday at 10:30, as long as you provide 9 days notice to the other side. So you couldn't schedule like next Monday because they wouldn't get 9 days notice. But if you schedule it by this Friday and send it out, you could get it heard on the following Monday, which would be the 17th, the 24th. You can schedule it for July 8th, any Monday you want, other than if there's a holiday.
Okay, noted.
What I'm going to do, Mr. Davis, in this matter, I'm going to adjourn this matter to August 21st, 2024 at 8:45 a.m. That will give you sufficient time to get the motions filed and heard, and at least we'll have that matter resolved. But you understand, notwithstanding that, you still have a sizable arrearage. And even if the custody's changed and your support amounts change, you're still going to owe an arrearage. You understand?
Yes.
Okay. We'll see you back on August 21st, and maybe before then if you file the motion.
Okay.
Okay. You're free to go. Have a good day.
You too. Thank you.
So, Your Honor, are we just going to continue those bonds then to that hearing?
What I'm going to do, I've got those bonds. I'm going to forfeit the bonds at this point today, and then we'll just see you back on the August 21st day.
Jennifer Norton, attorney Brad E. for the plaintiff.
Okay. Good afternoon to everyone. Afternoon, Mr. G. How are you?
Fine, Your Honor. Thank you.
Good. Mr. G, do you, again, this matters before the court on the petition filed by the plaintiff to exclude child. Do you wish to make an opening statement or simply proceed to the proofs?
You know, I'd like to proceed to the proofs, Your Honor. And if you wouldn't mind, I'd also like to take pro-con proofs as well today.
Okay. Ms. Norton, in this matter, you can make an opening statement, you can reserve your opening statement, or you can waive your opening statement. What would you like to do, ma'am?
I have no clue.
Okay, well, do you have a statement to make at this time? You have another chance at closing to make a statement, but do you have one at this time?
No, not right now.
Okay, go ahead, Mr. G.
Okay. Your Honor, the parties during their marriage, there was 2 children born to the defendant, and Your Honor, Brad G on behalf of the plaintiff, Andrew Norton. One of the children, Jonathan Michael Menke, is not biologically the plaintiff's child. The DNA testing results confirm that. They've been served upon the defendant. My understanding is she doesn't have any objection to those test results. That the plaintiff, it's my understanding that the plaintiff hasn't developed a relationship with this child. He's been having, I believe, nearly 50-50 parenting time with the party's biological child, but no parenting time with Jonathan Menke. And I believe it'd be in the child's best interest for this court to enter an order excluding party's marriage so that that child, so that the defendant may establish support and parenting time with the child's true biological father.
Okay, well, we'll take some testimony and to get a factual basis, and then we can do that. Who do you want to call first?
I'll call Andrew Norton, Your Honor.
Okay, Mr. Norton, we'll have you raise your right hand and then be sworn in.
And Andrew, I understand that Jonathan was born during your marriage to the defendant.
Yes.
And is that child a result of your relationship, your physical relationship with the defendant?
Yes.
Are you the biological father of Jonathan?
No.
No. Okay. Have you reviewed the DNA results, the test results concerning that child?
Yes.
And you understand that those results exclude yourself as the possible biological father of Jonathan? Yes. Now, have you established a relationship with Jonathan?
Throughout just seeing him, that's about it. But other than that,
do you have regular parenting time with Jonathan?
No.
Okay. And Jonathan is 2 years old, is that right?
Yes.
Okay. And do you believe it's in the best interest of the court, or in the best interest of Jonathan, for the court to find that you are not the father of the child and to exclude from your party's marriage?
Yes.
I have no further questions.
Okay. Ms. Norton, do you have any questions of the plaintiff?
No.
Thank you. Do you have another witness, Mr. G?
Sure, I'll call Jennifer Norton. Okay. But Jennifer, I understand that there were 2 children born during your marriage to the plaintiff, Andrew Norton. Is that accurate?
Yes.
And one of those children, John, is not a product of your relationship with the plaintiff. Is that accurate?
Yes.
And have you reviewed the DNA test results which were provided to you?
Yes.
And do you have any objection to the court accepting those results?
No.
And those results indicate that Andrew Norton is not the biological father, right?
No. Yep.
Do you agree that it's in Jonathan Menke's best interest that an order entered indicating that the child was born out of wedlock and not a product of your marriage to Andrew Norton?
Yep.
Was your answer yes?
Yes.
Okay. I have nothing further, Your Honor.
Okay. Ma'am, I note in looking at the petition in this matter, it shows that Jonathan was born in May of 2022, and the petition states that you had separated from the plaintiff sometime in 2020. Is that correct?
Yes.
So after the separation, Had you engaged in any sexual relations with the plaintiff?
No.
And, well, I won't go into that. Okay, I have nothing else. Anything else, Mr. G?
No, I would like to preserve proofs
Okay.
with Mr.
Okay, well, let's address this. Are you offering the DNA test report?
Yes, Your Honor.
Okay. And Ms. Norton, you said you didn't have any objection to that report being admitted as an exhibit?
That's right.
Okay. The court will accept the DNA test report signed by Deputy Kumar, PhD, dated May 1, 2024, which is a test on the defendant, the child, and the plaintiff, Andrew Norton, and it shows a probability of paternity of 0%. So the court will admit that at this particular time. Anything else, Mr. G? Any closing argument or?
No, Your Honor. My proposed order, there was a separate support case open in relation to this child. And I don't know if you want to consolidate those cases. It seems maybe to make sense and dismiss the other case, but I'm not sure how you'd like to address that.
Well, I don't have anything before me to consolidate it, so I guess I won't do it at this point until I get something if that comes up, but I will. Miss Norton, what is the birthday of Jonathan? Just the day. I've got the other.
5/15.
15? Okay, thank you.
Yes.
I need that to put in the order, so. I will, I don't think you have any problem with that if we go back to that date and exclude him. And again, would in fact eliminate any support at that particular time. Anything else?
No problem.
Okay. Well, there being nothing else, the court will note the court has heard the testimony of both the plaintiff and the defendant have confirmed that Jonathan Mike is not issue of this marriage and that the plaintiff is not the biological father. That would be confirmed by the DNA test report admitted in this particular matter. And both of the parties have testified they did not have any relationship or sexual relations after the separation in 2020, the child being born in May of 2022. So clearly there's no possibility or probability that he would in fact be the biological father. The court will therefore determine that he is that the child, Jonathan, is not issue of this marriage and that the plaintiff is not the biological father. And I will so provide for that on the order in this particular matter. Anything else, Mr. G?
No, except I'd like to preserve proofs.
Oh, correct. Go ahead.
Okay. Mr. Norton, you're still sworn in. Do you recall signing a complaint for divorce near the end of 2023?
So we went through we were going to go through the divorce at one point.
Excuse me, that was during February of 2024. Do you recall signing the complaint for divorce?
Yes.
Okay. At the time you signed the complaint for divorce, had you lived in the state of Michigan for 180 days?